Hello everybody, Dr. Stringer is back here with you. Glad to see that some of you have stuck around for the second module. So today we're getting into a little bit more of the course content than we did last week. Obviously last week we didn't have a whole lot going on, just basically introductions and looking over the syllabus. But still easing our way into the course. Today is going to be kind of an introduction to courts. For most of you, it is probably going to be a little bit of a review of the information that you learned in your 1101 course. So most of it will probably not be that much of new information, which I guess is good for those of you who are still not quite ready to get into the weeds with the learning of a lot of new information this early on in the semester. With that, we'll go ahead and start talking a little bit about why it's important to study courts. So in looking at courts, I've even done some research myself in sentencing with regard to sentencing inequality, especially for drug violations and things like that. I think it's very interesting to look into that sort of stuff. There's other people that do research on juries and things like that. And so finding out what is occurring in the court system is similar to researching other aspects of the court system, or the other aspects of the criminal justice system as well, such as policing or corrections, juvenile, the juvenile system and things like that. So it is important to study the courts and understand what's happening in the courts so that way we can try to improve upon them, because nothing is perfect. You've probably heard through some of your courses about all of the people that get wrongfully convicted, and we only know this through DNA evidence. But anyway, that's neither here nor there. It's a key thing to think about when you think about courts is that there's two main types of ways that courts really touch our lives, so to speak. There are criminal matters, and then there are civil matters. So for criminal courts, obviously, you would be accused of violating some sort of law, maybe drunk driving, or maybe more serious offenses such as murder and things like that. These all go to the criminal courts. Civil matters tend to be a little bit different. They're usually less serious. They might involve divorces, and if someone has been negligent in their car accident that you were involved in, you might decide to sue them for damages, things like that. And these things usually involve contract law or torts. Since this is a criminal, obviously a criminal justice course, we're not going to go into too much detail about civil courts. And then, of course, the burdens of proof are much different and all these other things. For our purposes, we're going to talk about criminal courts. So, if anybody has any questions about civil courts, send me an email or something like that, and we can talk about that, or come see me during office hours. But we're going to focus on criminal courts since this is a criminal justice course. The abstract goals, obviously, of the criminal courts are to have fair and equitable hearings, to have justice for the victims and society, and to maintain an open and impartial forum. But one of the big problems that burdens our criminal courts these days is they have incredibly overloaded dockets. There's just so many people coming through the courts that this kind of weakens the adversarial nature of the system. And it kind of makes actors attempt to kind of streamline the process, which has led to over 90% of cases being reached a plea agreement to, in which case there is no actual trial, just the defense attorneys and the prosecutors reach an agreement. And some of the sentencing research has actually said one of the big things that actually motivates offenders to do this is there's something known as the trial penalty. When it comes to being sentenced and convicted, if you go to trial and you lose, you will usually get a much harsher penalty than if you had just pled guilty. Because the judges are interested in not having a lot of time spent on each individual little case because they want to push more through the system as quickly as possible. Obviously, this leads to some issues as well, which we'll talk about throughout the course as well. So, just some general definitions. Looking at The court is an institution that the government sets up to settle disputes through a legal process. And there is a process. You do have a due process right to that process. And what happens is when people plead guilty, they're actually waiving that right to a trial, which is something you probably know if you've taken criminal procedures and things like that. And they adjudicate things. So adjudication is to hear and settle a case by judicial procedure. They will follow this procedure, and then the judge or the jury will make a decision. And so then there is an issue of jurisdiction. And jurisdiction is, the persons over whom the court has power, and the subject matter over which a court can legally make a binding decision. So there are different types of jurisdiction. We're going to talk a little bit about that just to give you guys a good foundation on that. And so the first one is jurisdiction geographically. So the court's entitlement to handle and hear disputes arising within specified political boundaries. If you get arrested in Cobb County, chances are you're going to go to court in Cobb County. You're not going to go to court in Fulton County. If you get arrested in Georgia, you're not going to go to court in Alabama because they do not have jurisdiction over what you do. So there is that jurisdictional or the geographical jurisdiction, obviously. There's also something known as subject matter jurisdiction. There are some courts which do not have a lot of jurisdiction. One of these might be the juvenile court. If you're a juvenile, then that court has jurisdiction over you. But if you're an adult, they don't have any jurisdiction over you. There's absolutely nothing they can do. And another example might be probate court. Probate court in Georgia doesn't have a lot of jurisdiction. They issue marriage licenses and gun permits and things like that. But if you're arrested for a crime, they have absolutely no jurisdiction over you, and you would go to a different court for that. And then there is an issue of original jurisdiction. So original jurisdiction is the court's power to try a case and issue a ruling. These would be your ordinary trial courts. If you're tried with a misdemeanor, chances are you might go to traffic court. Traffic court is another example of a place that only has a limited subject matter jurisdiction because they're not able to try felonies. You only go there for your traffic offenses. But they do have original jurisdiction over those traffic offenses. And then there's something called appellate jurisdiction. And this is the court's authority to review decisions that are made by a lower court. And so, interestingly, you'll see that there are some courts that have both original and appellate jurisdiction. And these would usually be your courts of general jurisdiction. So your general jurisdiction courts would be your felony courts, your courts where you have original jurisdiction, and I forget what it's called in Georgia. But these courts also have original jurisdiction to hear felonies. But if you appeal something from traffic court, then you would go up to this next level of court, which also has appellate jurisdiction over the lower courts with the lower subject matter jurisdiction. So these are your courts of general jurisdiction. They can hear pretty much any case that's put before them, and they have that original jurisdiction on those cases. They also have the appellate jurisdiction to review those cases from the lower limited jurisdiction courts, your probate courts, your juvenile courts, your traffic courts, things like that. And so getting into this, this is obviously your state courts of limited jurisdiction. AKA your lower courts. And there's a ton of these. There's about 14,000 courts that hear 80 plus million cases a year. And they're usually your local level courts. They have jurisdiction over misdemeanors, traffic infractions, civil suits. I forgot to mention that one earlier. And then you have, like I said before, your specialized courts. Your family courts or drug courts is another big one too that's starting to become more popular. They're also coming up with DUI courts nowadays, and then again your probate courts. These courts also have limitations on their sentencing options. These courts, because they're unable to try felonies and they don't have jurisdiction over felonies, they cannot sentence you to anything more than 12 months in jail. If you're going to go up for a felony, this is another reason why you would have to go to that court of general jurisdiction. Looking at the state courts of general jurisdiction, these are AKA your felony, your superior, your circuit courts. and these are the courts that have that general jurisdiction. If you are charged with a felony, you will go to this court because this is the court that has the original jurisdiction over a felony. If you're charged with a misdemeanor, chances are you're not going to go to this court first unless you appeal. You would go to one of those lower level courts, such as your local level, traffic court, probate court, things like that. These courts also handle larger civil matters, and it varies a little bit across different states, but civil matters that involve a lot more money, they will hear this, and it varies a little bit. It's a few $1,000s. Then the lower courts might hear it, but if it's several $100,000 or millions of dollars, then you're going to have your larger court is going to have that jurisdiction over that. This is also the highest level trial court at the state level. If you do appeal from your state court of general jurisdiction, you will not get a new trial, or a trial de novo, as it's called in Latin. You will simply be being heard by the appellate court, who will then make a decision based upon the transcripts and the record of the case to see if there's been some sort of legal error. And so then that gets into how I was talking about before. Your state courts of general jurisdiction also will hear appeals from the limited jurisdiction courts, so your probate courts and traffic courts and things like that. And in these cases, you actually will get a new trial. So because the lower courts are not courts of record, your limited jurisdiction courts are not courts of record, you will actually get a new trial when you appeal to your general jurisdiction court, because there is no record for them to review. And so you will actually get a trial de novo, which actually gives them this actual court of original jurisdiction as well as appellate jurisdiction, which is interesting. So your state appellate courts, these are responsible for hearing appeals from the courts of general jurisdiction. And you might actually end up with a case that starts off in traffic court, and then it gets appealed to your court of general jurisdiction, and then maybe you might even appeal it again to then your appellate court. In some cases, some states have two different levels of appellate courts. So you might have a regular court of appeals, which would be your first level that you would appeal to after your trial, and then a lot of states have a state supreme court, which is then the final appellate level within the state. And so that would be your final appeal at the state level would be to the state supreme court. And then your next level, which you could possibly try, would be the United States Supreme Court, if you can get them to hear your case. And we'll talk a little bit about that as we move forward, too. So this is kind of the basic structure. I've tried to use a little bit of the same language that's in your book as far as appellate courts, limited jurisdiction, and general jurisdiction courts, because different states call them different things. So, for example, in New York, if your trial court in the state of New York is actually called the Supreme Court of the state of New York, which can be kind of confusing because in most states, the state Supreme Court is this final appellate court, the highest ranking court in that state. However, in New York, it's different, and the final appellate court is called something different, and your state Supreme Court is actually your trial court of general jurisdiction. So I try not to use this language with state Supreme Court and things like that because it varies so much across the different states. And so this language of courts of limited jurisdiction, courts of general jurisdiction, and appellate courts, you can use that across different states regardless about what they call their different courts that fall into those different categories. So I hope that makes sense. Oh, I hit the back button there. So one of the things when you look at federalism and uniformity is that we have a dual court system that includes 50 separate state courts and a federal court system. And it's not to mention the thousands of county and lower courts that you have. So it is rather inconsistent. Is that example that I gave you how New York calls their trial court the New York Supreme Court. In Virginia, the New York Supreme or the Supreme Court is actually that highest appellate level, and similar in Georgia. And so these things are a little bit decentralized and can be somewhat disorganized when you're trying to apply the same ideas across different states. And so this is why in your author of your book uses a similar language too. It's not to say that the state Supreme Court is not what it is, and certainly the U.S. Supreme Court is one thing, and that's not going to vary in definition because there's only one of them in the U.S. Supreme Court, and we'll talk about that when we get into the different federal courts, which we're talking about right now. So your federal courts, they are where you're not very likely to go unless you've committed a very, very serious crime that probably involves some sort of offense that involves crossing state lines or something like that. But generally they will hear cases that will involve the United States as a party. They also hear cases when one of the states is a party. So if you had a suit against the state of Georgia, you could actually sue them in federal court, which is, obviously a good thing. You wouldn't want to sue the state of Georgia in a Georgia court because there's a bit of conflict of interest there, right? One of the big things too that the federal courts were here is cases involving the U.S. Constitution or the constitutionality of a law passed by Congress. And this is one of the things where the federal courts enjoy original jurisdiction. As a matter of fact, all of these things they have original jurisdiction over, which means that the federal courts can hear the case the first time. The federal courts also, or at least the United States Supreme Court, actually has appellate jurisdiction over the state courts too, which we'll talk about later. And so they might actually hear cases involving citizens from different states, or some special types of cases, bankruptcy and patent cases and things like that. Although these are much different than criminal cases, obviously. And so, moving forward, your federal courts, your courts of general jurisdiction, your trial courts are called the district courts, and so just to clarify, all these definitions for the federal courts, the names of them are all the same because they're all defined by the federal court system. So your district court in Alabama is still called a district court in Georgia, Virginia, New York, everywhere else. Your federal district court is still a federal district court across all the states, wherever you go. The same is true of the circuit courts, which we'll talk about next. So they hear, fewer than 100,000 federal cases. Only about 4% of them are for violent crimes, and this is usually a violent crime where, someone has probably killed someone on federal property, or a violent crime occurred on federal property, because a lot of this stuff is going to be handled at the state level. There's 94 districts throughout the U.S., and they hear cases on violations of federal laws, as well as violent crimes through the Federal Assimilative Crimes Act, which means that if you commit a violent act or a criminal act on state property, or on federal property, within a state, then the state law that you're in actually applies, and they will then prosecute you under that in federal court. For example, I actually had an uncle who was on federal property in the Outer Banks of North Carolina, and he got a DUI. And he's one of the few people I've ever heard of that got a DUI, and a federal DUI. If you think about most people that get DUIs, they're going to go to state court. But he was actually on the area of the Outer Banks. There is some sort of federal national seashore or something like that, like a national park or something. And so he got actually pulled over and stopped by a federal park ranger. And so he ended up going to federal court and was on all sorts of probation and all this stuff for having a drunk driving offense. One of the few instances where you'll see someone get a federal charge for something like that is if it occurs on federal property. So the U.S. Circuit Courts, or the U.S. Courts of Appeals, are circuits. We call them circuit courts sometimes. We usually call them U.S. Court of Appeals. And so if you got an adversarial finding, you're found guilty in the federal court, in the trial court, you could appeal that to the U.S. Circuit Court. And so one of the things that sometimes people get confused is You can appeal a state decision to the U.S. Supreme Court, but the U.S. Supreme Court is the only court that has the power to review that decision or that guilty verdict from a state court. You can't appeal that to the Federal Court of Appeals. They do not have jurisdiction over the trial courts in the state of Georgia. However, the U.S. Supreme Court does. So there's 12 different circuits of courts of appeals, 11 for state, and there's one for D.C. There's actually a couple more that I think your book talks about, and that involves appeals from the military tribunals and things like that, which are not particularly applicable to this class. So they will review cases from the federal district courts, and so then they can actually look at that sort of thing. So cases are heard by a panel of 3 judges, and this is what usually happens. Now, if you do get an adverse decision from those 3 judges, you can actually move for an en banc trial, which is when you can have the entire panel of the judges review the case. So moving forward, you can also see that the federal courts, the U.S. Supreme Court, is the highest appellate body in the U.S. It is the Supreme Court of the entire country. It is the end-all be-all. There is no court in this country that can overturn a verdict from or an opinion of the Supreme Court except for the Supreme Court itself. And that has actually happened where the Supreme Court has overturned decisions that they've made maybe 30 years beforehand, and they've changed things over time. And so the Supreme Court is the only court that can do that, the U.S. Supreme Court. And so it hears appeals from the U.S. Circuit Courts. And so if you're maybe you had a trial in one of the district courts in the federal system, and then you appealed to the U.S. Circuit Court, and you didn't like that outcome, you could then appeal it to the U.S. Supreme Court. And another thing that will happen too is you can, like I said before, you can appeal state decisions from or to the U.S. Supreme Court. And so before you can do that, you must exhaust all of your options within the state, meaning you have to have gone through the entire appellate process within the state. So maybe you were tried originally in the court of original jurisdiction in that state, the circuit court or whatever it's called in that state, and then you were tried, you were convicted, then you appealed to the Court of Appeals in that state, and then they affirmed your decision, the finding of guilt, the verdict, and then you appealed to the Supreme Court from that state, and then they affirmed. Now, then what you can do after you've exhausted all of these is you can apply to the U.S. Supreme Court to have them hear your case. They're only going to hear your case if it involves some sort of constitutional issue that violates the U.S. Constitution. So if they will not issue any kind of certiorari if you're just arguing the facts of the case. The facts of the case are irrelevant. They will take the facts as they are, as they have been found out in the original trial. All they're doing is trying to figure out whether there was some sort of due process or other constitutional rights of yours were violated. So maybe there was some sort of illegal search and seizure, or they didn't read you your Miranda rights or something like that, and this evidence got in when it should have been excluded, things like that. So the Supreme Court is comprised of 9 Supreme Court justices. The Chief Supreme Justice, the Supreme Court Justice is right now John Roberts. They are appointed for lifetime appointments. They're appointed by the President and approved by Congress. As you could probably remember, recently there was all this controversy over Brett Kavanaugh being appointed by the President because Congress didn't want to approve him, and eventually they did. And this ended up being very politicized, and it was obviously in the media a lot. So as I said before, they have discretion to hear an appeal. They do not have to hear them, and the vast majority of appeals they do not hear. The vast majority of people who apply to have their case heard at the Supreme Court do not get heard. There is something known as the Rule of 4, meaning that if you apply to have your case heard by the Supreme Court, 4 of the justices out of the 9 have to agree to hear your case. And if 4 of the 9 justices agree to hear your case and the rule of 4 is met, they will issue what is known as a writ of certiorari, meaning that your case has been accepted into the U.S. Supreme Court and you will get your case heard by the Supreme Court. There's a bunch of different criteria that the Supreme Court uses, and if you take a constitutional law class, then they will go through all this details of the different issues that the Supreme Court considers when they're deciding whether they want to hear an issue or not, such as the issue being moot or something like that. A lot of times what will happen is the Supreme Court will hear an issue if maybe there's conflicting opinions amongst the different courts of appeals in the different circuits. So maybe, I don't know, for Miranda rights, maybe the Ninth Circuit has said that you don't have to read some of their Miranda rights, but then the Fifth Circuit has said that you do, and then so the Supreme Court would hear an issue on that to say, well, we're going to resolve this issue here. With that being said, of course, Miranda rights isn't the best example because Miranda has already been decided by the Supreme Court, so there would be no difference of opinion amongst the Supreme Court or the appeals courts as to how to interpret that, because that's binding on them by the Supreme Court opinion in Miranda versus Arizona in the 1960s. So that's just an example of how different circuits might have different opinions, and they're allowed to do that as long as it doesn't conflict with what the Supreme Court has said. And another interesting thing to think about too is the circuit courts, the courts of appeals at the federal level, they do not have jurisdiction over appeals that do not occur within their circuit. So suppose there is an appeal from a case in the Ninth Circuit, which is California and over there. And I use the Ninth Circuit as an example because usually the Ninth Circuit is the circuit that doesn't really agree with the things that the opinions of the other circuits. Well, then that decision by the federal appeals court in the Ninth Circuit is binding. It does create precedent across all of those lower district courts in the Ninth Circuit. So the Ninth Circuit courts have to abide by that decision. But the district courts in the Fifth Circuit, they don't have to abide by that. That's not binding on them. They can still do whatever they want as long as it's in accordance with what the federal appeals court for their circuit has said on whatever issue it might be. So the U.S. Supreme Court generally hears about 300 cases a year. About 80 cases get to oral argument. So that's pretty few. And there's a majority opinion, and then there's usually a dissenting opinion. So if everybody doesn't agree, then there might be a dissent. You've probably heard of this before. When it comes to ruling on the case, it must be a majority rule. So 5 out of the 9 justices have to agree to either affirm a case or remand it and things like that. And if they agree, then that sets precedent. And then everybody in the entire country has to abide by whatever the court has said on that matter. The federal courts, the state courts, everybody all the way down to those courts of limited jurisdiction, the traffic courts and everything, have to abide by what the Supreme Court says. And then when you have like this 5-9 ruling, you'll end up with that majority opinion that represents the opinion of the 5 justices, and then you might have a dissenting opinion that represents the opinion of those 4 justices. And the dissenting opinion is not binding. It does not set precedent. However, that majority opinion does. And it's interesting, if you end up studying constitutional law, you'll find that over time there's this saying that the dissenting opinion of one opinion or one era of time often becomes the majority later on. And so the dissent from the 1930s ends up becoming the majority rule down the road, and that involves changes in politics and different justices being appointed and things like that. But that's a little bit more detail than I guess you all need right now. So appeals can only be filed if the defendant believes that a legal error has occurred. And I touched on this before, and/or his constitutional rights were violated. So if you file an appeal, you don't get to argue the facts again. They are not going to care. The facts have already been decided. You file an appellate brief, you'll be saying that based upon these facts, that either my constitutional rights were violated, or there's been some other sort of legal error. Maybe the judge allowed some evidence that shouldn't have been allowed into the trial, and in doing so, it was prejudicial against you or something like that, and this adversely impacted the guilty verdict or something like that. And if cases are heard, only oral arguments are held. You'll file a brief, and then you'll get the oral arguments. And one of the few things you'll probably see that is actually correct in the maybe Law and Order or stuff like that is they have the podium up there, and on appellate arguments, you have the light with the green, the yellow, and the red. When the green means that you have time and you continue to talk, and yellow means you only have a couple minutes left, and then red means your time is done, and so that's it. And so you'll usually get about 60 minutes in the U.S. Supreme Court, and that varies a little bit across different states. Might give you a little bit different time frames, but so you don't need to know obviously all 50 states regulations on all of this. So there's three options for appeal verdicts. They can uphold the decision, in which case you're going to prison. They can overturn the case and release the defendant and say, no, you're not guilty. This very rarely happens. What usually will happen, even if they do agree with you, so to speak, on the appeal, they will reverse your conviction, but then they will remand the case back to the lower court to retry you in consistency with what they've said the court should have done. So if you win your appeal and maybe the Supreme Court says that whatever evidence was used to convict you should not have been admitted into evidence against you, then they will then reverse your conviction and remand the case back to the lower court to retry you if they so choose to do so. And then when they retry you, they're not allowed to use that evidence because the Supreme Court has said, or any court of appeals has said, that this evidence should be excluded. And what might happen is, it might be remanded back to the lower court, and the prosecutor might decide that, without this evidence, it's not worth pursuing the charges, and then they might decide to null pros the case, in which case you don't get retried. So that could happen if this was a key piece of evidence that gets excluded. So moving along from there, just to look at a few of the different actors, so to speak, in the court process. The first one is the judges. And so they're kind of the referees in the trial process, and their duties are to make rulings on appropriate conduct of the courtroom actors, to guide the questioning of witnesses. They oversee the juries. They decide or rule on the cases or issue a verdict in the event of a bench trial. And they usually involve sentencing the defendant, except for there's some states where if you have a jury trial, the jury actually issues the sentence along with the verdict. And then they oversee the courtroom personnel, and they'll also be charged with making rulings on decisions of law, like whether some evidence should be excluded or admitted. There's a bunch of different rules on procedure of different law or different exclusions about evidence and witnesses and all that kind of stuff that you'll get into in probably criminal procedure or another course. So the way that judges are appointed or elected kind of varies a little bit across states. In some states they're appointed by the governor, and in other states, there's just kind of a popular election. I believe Georgia is an election state where there's just an election every year, just like the governors and things like that, and you would then be charged with electing your judges. This involves a little bit of politicization of the system, I guess. I know that back in Virginia, where I'm from, they're appointed by the governor, and almost all of the judges are former prosecutors. Virginia is a very conservative state, and oftentimes they're appointed by Republican, governors, and so you end up with a lot of judges who are former prosecutors and are very conservative. And so it's interesting because sometimes you'll kind of see that former prosecutor mentality is there, and so then you might not have quite the neutral arbiter of law that you might hope to have. because you bring in all of this prior experience as being a prosecutor and all this life experience and that. Some judges have actually been prosecutors and defense attorneys. There's an old saying that people become prosecutors maybe when they first get out of law school, but then the money's not that good in that, and then they eventually become defense attorneys, and those are some of the best defense attorneys have actually been prosecutors first. But anyway, then there's this idea of the Missouri Plan, where they tried to kind of get away from the problems and the issues of politicization between governor's appointments and elections. And they have this judicial nominating committee, which is not a political committee, which then makes recommendations to the governor, and the governor appoints whoever they choose from the committee's nominations, and then one term later there is an election for the public to elect to choose between whoever the governor has appointed. He usually appoints multiple people, and then there's an election. The prosecutor has, obviously in the adversarial system, has the job of prosecuting defendants, investigating and charging decisions. They get to decide what they're going to charge someone with, if they're going to charge someone at all with an offense. Maybe you shot someone, but it was in self-defense, and they might not decide to charge you at all. They have that discretion. Prosecutors have a lot of discretion. They'll interview witnesses, review warrants and subpoenas, conduct pretrial hearings, negotiate plea bargains, conduct criminal trials on behalf of the state, and provide sentencing recommendations. And like I said, they are, the most powerful member of the courtroom work group. A lot of people think that the judge is, but given so much proliferation of what's known as determinate sentencing these days, a lot of the power of the judge has been removed from the judge himself and given to the prosecutor, because determinate sentencing really kind of it tells the judge, hey, well, if this person's convicted of this, then this is what their sentence is supposed to be. And so a lot of it is given a lot of the power to the prosecutor, because the prosecutor has a huge amount of discretion. He can charge you if you're urinating in public, for example, in some in some states. He can charge you with maybe indecent conduct or something like that. But in some states, he could actually charge you as a sex offender. In which case, for urinating in public, you might be on a sex offender registry and things like that. You might even go to prison as a sex offender, or go to jail, or, so that's all in their discretion. And then they have the discretion to nolle pros things, which is to not charge you at all. And of course, the judge has nothing to do with any of this. You can be charged with a serious crime. You can be charged with not that big of a crime. You can be not charged at all. What usually happens is prosecutors tend to overcharge, is what a lot of things tend to find, because they want to be able to negotiate a plea agreement. And so if they charge you with something greater than they think that they can actually convict you of, then they can negotiate better, because you've been charged with a sex offense, and then they'll meet with your defense attorney and say, hey, what if we just plead guilty to indecent conduct or something like that. There are things known as prosecutorial misconduct, and one of the biggest ones was in North Carolina recently, and I think we'll talk about it later on in this class, with David Nifong, and it was a Duke case with sexual misconduct, and he was making it very politicized and talking to the media a lot, and it's very unethical for a prosecutor to do. And he was actually the district attorney for the area. Usually there would be an assistant district attorney, but he was running for re-election, and so he kind of politicized this case and decided to try it himself to kind of help with his election that was upcoming, and that ended up causing a lot of problems for him. And then there is the defense attorney. The defense attorney is the individual, obviously, who's charged with representing the defendant. They can be privately retained, or they can be publicly provided, usually for indigent persons. So those people that can show that they can't afford to hire their own attorney, the state will provide them one. And their real functions are, to interview the client, the police, potential witnesses, and then to represent the client in the pretrial and trial procedures, which we'll talk about later, as well as plea deals with the prosecutor. Like I said, over 90% of issues are usually resolved through plea deals, and obviously this is a big it's really in the interest of the defense attorney, because usually what they'll do is charge people a flat rate. So I'll represent you for this on this case for $5,000, and he keeps the $5,000 even if he gets a plea deal or if he goes to a full-on jury trial. Obviously, one is going to be a lot more time-consuming than the other, and take a lot more effort. And so, you know, your issues with indigent defendants all comes with Gideon versus Wainwright, who says that all defendants in state and federal trials have a right to counsel, and indigent people will be provided counsel. This is if you're facing jail time. If you're not facing jail time, you don't have a right to counsel. And this has evolved a little bit over time. It used to be you only had a right to counsel in if you're indigent in cases that was involved in felony. Now you get it if you're an indigent person. If you're facing any jail time, then you might be able to prove that you're indigent. You can't afford your own attorney, in which case they'll appoint one for you. Sometimes what happens too at the lower courts is if the court doesn't feel like appointing you an attorney, what they'll do, and it's a misdemeanor offense, they might just waive jail time, in which case the judge will say, okay, well, I'm waiving jail time, and this is probably some sort of petty matter like driving on suspended license or something like that, and the judge is really doing this to save not only himself time, but to help take a little bit of the burden off of the public defender's office. And he's saying, okay, well, this is a petty offense, it's a misdemeanor, I'm not going to give you any jail time if I do convict you, so therefore you don't have a right to a lawyer, because your right to an attorney, or right to a court-appointed lawyer at least, is tied to your facing of jail time. You still could hire your own lawyer if you wanted to, but the state would not appoint one for you. So these actors that I've talked about are kind of all a part of what is known as the courtroom work group. And there's this courtroom communities theory, which goes to talk about how the judges, prosecutors, and the defense attorneys all kind of form this local legal culture. And a lot of them become kind of friends, and they work together day in and day out. And they're there from 8 a.m. in the morning till 5 p.m. Working together. And oftentimes they'll go to lunch together and things like that. And they have kind of this mutual respect for one another. And kind of end up with this shared understanding of how cases should be processed. And that actually helps them to be able to process cases faster, but it also might resolve in more plea bargains. It actually has been shown to decrease a defendant's outcome or his sentence if he has a lawyer who's part of this courtroom work group. Versus hiring a lawyer from another area or representing oneself, because these people are not part of the courtroom work group. And so this leads to other issues, obviously, too, and this is usually characterized by negotiation. They're able to negotiate with each other a little bit better, they're all friends, and so trials don't really become predictable, and they don't like that. They would rather just negotiate amongst themselves, because then they can figure out what the outcome is going to be. Trials, especially jury trials, you don't really know what's going to happen, and they take an enormous amount of time and energy and expense, so they tend to try to streamline this entire process with making plea agreements on a lot of these cases. So one thing to note is the defendant, who there is usually a defendant in a criminal case, is not part of this courtroom work group. And as well as not being part of that courtroom work group is also not the jury. And so these people are not part of these three judge, prosecutor, and defense attorney who make up that kind of triangle of the courtroom work group. And so one of the big ideas, if you take a class on juries, goes back to kind of removing the lawyers from the decision and kind of brings it to the jury, which then makes the jury representative of the community, allegedly, and then they make a decision on guilt or innocence, which Some people have tried to predict these things, but even the best of professionals out there have trouble predicting what a jury is going to decide. Usually this involves interviewing juries after the fact, or even creating mock juries to present the trial to see how people are going to react to different pieces of information. Usually a jury will be conducted based upon what's known as a veneer, which is a group selected for jury duty, and then there will be a process known as voir dire, in which potential jurors are interviewed and asked questions by the prosecutors and the defense, and then there are challenges. So you have challenges for cause, and then you have peremptory challenges. Challenges for cause would be if you asked someone if they were a member of the KKK and your defendant was African American. Well, obviously that's a challenge for cause, and then you could just challenge them for cause and have them removed from the jury. Or things like that. In death penalty cases, we have something known as the death qualified jury, which means that you have to ask the jurors if they would be willing to give the person the death penalty if they were convicted. And if they say no, you can challenge for cause and say that they're not a death qualified jury. This leads to a lot of issues too, though, because most of the people that would be pro-death penalty are also more conservative and more likely to convict people anyway, and so then that makes the prosecutor's job a little bit easier. There are also something known as what is called a peremptory challenge. A peremptory challenge you do not need to have any cause for. You just say, thank you, juror number 2, and I'm using one of my peremptory challenges. Usually what will happen is in most states in the federal system, you'll be issued a certain number of peremptory challenges. So maybe the prosecution might get 3 peremptory challenges, and the defense might get 6. And what will happen is you don't have to give any reason for excluding someone based upon your peremptory challenges. But you only get a certain number of them, so you have to use them wisely. There has been some research to date that has looked at kind of racial bias in the way that prosecutors might use their peremptory challenges. And so, particularly in some areas of the country, if you had a African American defendant and a white victim, the prosecutor might try to keep African American people off of the jury, and so you can actually argue that they're using some sort of systematic racial bias in the way that they're using their peremptory challenges. That has worked in the past, although it's kind of challenging to prove. However, if you can prove that, and it's been proven on appeal, then the case will be reversed and remanded because of your violation of your due process rights. So that's been one thing that's happened in the past. So one thing to be cautious of and mindful of when it comes to peremptory challenges. Just a few other actors in the courtroom. You guys that have been to court have probably seen that you'll have bailiffs, which are usually sheriff's deputies or U.S. Marshals in the federal system who are there, who provide courtroom security. Usually if anyone gets unruly, they'll make them leave, and they'll also move defendants who are being held in the back in custody and bring them out to the table, to the defense table, and then kind of stand around them and guard them so that they don't try to make a run for it. Also, if someone is free and then the judge has ordered them to be taken into custody, they'll be the ones charged with doing that as well. And then you'll have your court clerks, who are people that you've probably seen them too. They're kind of in charge of handling all the paperwork and all of this kind of stuff. And Supreme Court clerks actually get paid very well, and they're in charge of doing a lot of the legal research at the appellate level for the appellate judges. And they go off, especially if you work at the U.S. Supreme Court, they'll go off to make a lot of money after their clerkship is done. Justice Scalia, one of his last things that he wrote before he passed away, was talking about how his former clerks would go off to make more money than he did. So that's interesting too. And then you might have probation officers in the courtroom. as witnesses. You might have police officers, such as, if you're arrested for a DUI, obviously the police officer that arrested you is going to be there to testify as a witness. And then any victims to a crime would be present as well. Even though they have very limited input, and their role is kind of similar to that of the lay witness. If you are on a more serious offense, or sometimes even for a more minor offense like a DUI, you might even have some expert witnesses like myself who might come in to testify to different things, and so you might have a criminologist or a forensic scientist or something like that that might be an expert witness that might be able to shed light on a case. So with that being said, that's pretty much all I had that I wanted to talk to you all about. We're going to get into pretty much all of this stuff in a lot more detail in the coming weeks. And also remember to do your readings for the week before you do your quizzes and midterms and things like that, because just because I don't cover something in the lecture doesn't mean that it's not going to be on your midterm or your quiz and stuff like that. I've talked to you all for about 50 minutes now, so obviously we can't fit a whole lot of everything in here, as I know you don't want to listen to me for too long, and so please be sure to read through your textbook and get all of that material too, because it is important. So with that being said, I hope that all of you have a good week, and please email me if you have any questions, and I will talk to you all next week.